Hi, this is immigration attorney Ms. Bhat Chaudhary. I hope you are doing well, and we have been online after a while because of all the elections and everything going on, and we thought at our office that we should give some time to figure out how the things are shaping up, and we have stuff to discuss about any immigration changes which has come into live stream, and we have certain regulations which we'll be discussing here today. One is the H1B, and the other one will be about DACA. So what has become of it is that U.S. District Court for the Northern District of California vacates the strengthening the H1B program interim final rule. So this is the statement which is given by the Department of Homeland Security as per the ruling which came from the U.S. District Court. So what is happening, that Department of Homeland Security was suggesting certain changes along with the Department of Labor with regards to the H1B program, and they were supposed to implement those on December 7th, to which the U.S. District Court for North District of California vacated that decision, and they said they came up with the rules which were earlier implemented and were being in practice for the H1B. We are still waiting for further notification by the DHS how they are going to proceed with that, with regards to the salary, with regards to the wages level, with regards to the definitions which they have entered into for the subcontractors, for the employers, for the definition of the company. So we are still waiting on any further advancement and the implementation notification from the Department of Homeland Security, and we are hoping that this will go back to the time which we are familiar with for years and years and years, where we implement the quota system in the H1B. It's 65,000 for the bachelor's degree holders and 20,000 quota for the US master's degree holders. And things were doing very well on that, though the numbers still considered to be very low for the professionals and the skilled workers in the US, because they are much needed over here in different fields of life. But still 85,000 was working well. They were picked up based on the lottery system, and then the Department of Homeland Security works on these petitions. If they have any questions with regards to that, they will issue a list of documents which we call RFE, request for evidence, and where they ask the employers and ask the attorneys to provide with that information, and once provided and accepted, these H1Bs got approved, and the H1B candidates start working with their companies as the employees on effective October 1st of each year. So we are looking forward to that. We are hoping that things will come up really well as the total implementation of this judge's order will take effect, and we will see that how it's going to proceed. Further, talking about DACA. So DACA is in the U.S. immigration scenario for years and years. These are the people, these are the children, these are the people living in the United States for years and years and years, even from their childhood. And there were certain requirements which were established that if they meet those requirements, they will be eligible to file under DACA. And then once those, there were two checkpoints there. Number one, the checkpoint is that once they meet that certain requirement, there is no criminal charges, taxes are filed, education level, age requirement, all that, and they were taken into effect. And once the candidate, any candidate that fulfills all those requirements is eligible to file the DACA application. And once the DACA application is filed, it is again scrutinized and gone through the process of checking and seeing that this guy qualifies for the DACA status, and based on that they become qualified for the work authorization also. So that was a very strict check and balance system was established initially under which the DACA applications were filed. Now what happened is that according to the judge's order, the administration must post a public notice that will accept new applications from the Obama era program shielding undocumented immigrants who came to the US as children from deportation. A federal judge ordered Friday. So as per Judge Nicholas Gorofis, he said that this ruling should take into effect, and instructions should be issued by the Department of Homeland Security, and they should start accepting these applications from the candidates, and even the new applications from the candidates, which includes the work authorization application also for 2 years time period. So this rule has come into effect, and again we are waiting from the DHS to come up with the regulations, how it's going to be implemented, how we are going to start filing the applications for the candidates. We are here at the Ms. Chaudhary and Associates immigration law firm. We are all ready for that and waiting for them to come up with the final implementation rules. So we are come up with the documents requested and to start the process. If you need any information, as I have not mentioned earlier, you can see that on our screen. Our address is coming there, our email address to contact us. Furthermore, we are on all mediums, and you can see that it's LinkedIn, it's Facebook, it's Instagram, it's Twitter, and on our website, which is mispachadri.com, you can get all the information about us. And we are looking forward to file these petitions for our clients. So that is there. If you have any questions with regards to that, because it's a new process again, and candidates are getting very anxious about it, and we are receiving calls with regards to how it's going to process, what kind of documents will be needed. So any question like that will be answered as you question them. I'm really excited to see you guys all and to talk to you via screen after I think so a month's time period, and I'm happy that we can communicate. You can go watch our YouTube videos also. This will be uploaded on the YouTube as well. If you have any questions, you can send us emails so we can respond to your emails accordingly. So we have received certain questions, and in the meanwhile, I would also like to discuss basic criteria in certain ways where we look into things, how to handle different immigration cases, what kind of documents are required, how we can put together the documents, how effective those documents can be for us, what documents can be avoided. So I think so it is very important not to pile up the documentation which is irrelevant. The documents provided to the immigration officer along with the petition should be the relevant documents. The relevant documents which are relevant to the petition which you are filing. If you are filing an asylum application, you need to provide them with the supporting documents which will support your claim, which will support your grounds for filing the asylum application. If you are filing L1A visa, if you are filing for the intra-country visa, intra-company visa, sorry, and you are filing the supporting documents which needs to be added in are related to your job with this company, related to your profession, related to your experience, how you qualify for this job, for how long you have been working with this company, and certain other criteria. So my point in that is, if you pile up the officer with irrelevant documents, he won't be a happy person. And while he'll be going through these documentations, instead of looking at that pile and going through that, it will be a waste of time for the officer, and he is not going to, you will get a request for evidence, and it won't be able to provide any clarity with regards to your petition or application. So it's very important that relevant documents are provided. Also, it's not that you just fill up the application or petition and send it over without any supporting documents. It's very important that you compile your case and you make your case strong. Because if your case is not supported with the supporting documents, then there is nothing much that can be done about that. Or the officer can send you a laundry list of the required documents which you won't be able to provide later on. So it's very important that you consult with the attorney and let them know what kind of case they have, and provide the documents as the attorney ask you for or request you, so you are able to put in your case in the most strong way, and it is easy or pleasant even for the officer to review your case and to approve the matter. So this is very important, that needs to be taken care of, which I've seen that people sometimes just skip on this, and then they come to the attorney, they receive these RFEs or they receive these intent to deny, and then they panic. And or if they have already provided the officer with an irrelevant or incorrect document, which instead of supporting your case can hurt the matter. So then they panic and they come to the attorneys and they ask for help. So sometimes you can help and sometimes it's too late to help or to make correct what is wrong. Or the documents which has already been provided, which you cannot change, or irrelevant documents. So this is very, very important to take a legal advice on that and to petition in the right manner, so you have more possibility of rapid approval for you. We have received certain questions. We have received number of questions during all this time, which I have tried to respond, and our other legal staff has tried to respond via emails or via messengers, or via they have sent us questions even through our LinkedIn questions. Then they have sent us questions with regards through our website also. So if you have any inquiries and questions, we try to answer them, and we have tried to answer them during all this time. And there are certain questions which we pulled up, which were in our opinion not answered, and we try to answer them now. And we'll see if you have any other question, if you want to ask for more information, or if you have any immigration advice that you want, you can contact our office, schedule an appointment, and we will try to help you on that. So the first question which I have over here on my list is that, while I am in Abu Dhabi, can I process E2 investment visa? This is Mr. Saifullah, who is in Abu Dhabi, and he wants to process the investment visa, but he wants to make sure that if he is not present in United States, can he still process the E2 visa? E2 is the treaty investment visa, which is based on the treaty between America and certain countries. It's not for all the countries, but it's for certain countries who are on that list of E1 and E2 visas, petitions and the treaty. So Mr. Saifullah, if you are present in Abu Dhabi right now, if you meet certain requirements which qualify you for the E2 visa investment, after doing the investment, company formation, how you transfer the money, all that, yes, you can still get that done, which we call the visa stamping. You can get that done through the consulate process. So if you are not in US, and if you don't have a visit visa, which you can come in, or any other kind of visa, and can apply for the change of status within United States, you still have the option available that you can apply for the E2 visa through consulate process. Second question is, I'm on the J1 visa as research scholar in the USA. I have 2 years 212 waiver restriction on my visa. What can I do to stay here? Nathan Nasaya. So this is Mr. Nathan Nasaya. He's a question. He's currently in United States on a J1 research as a research scholar on the visa, and he has a restriction. So the J1 visa holders, sometimes they have to meet certain requirement, and that is called the J1 waiver. They can put in the J1 waiver. They can apply for the J1 waiver within United States, requesting the waiver of this restriction, this requirement. There is certain process, several processes are involved. If you need any details, kindly contact our office and we will happy to assist you. We do J1 waivers all the time. We will happy to assist you based on further facts and further questions with regards to your status. So it depends what are the facts involved, and based on that we will be able to get you proper advice on the J1 waiver. But yes, definitely you can apply for the J1 waiver. I have worked with a company for more than a year. The company is in existence for 10 years. So this is another question, but it says that I worked with a company for more than a year. The company is in existence for 10 years. I left to work with some other company in between and then rejoined this company last year. Can the company apply for an L1A visa based on the employment period qualification? That is Mr. Raj Kumar Sahgal. Mr. Raj Kumar Sahgal, what I am understanding from your question is that you are working with a company for certain period of time, more than a year you are saying, and this company is in existence more than 3 years, so that there it meets certain requirements for applying a petition for the L1A. And then you are saying you are again working for this company. So I think so your question is that the previous qualifying time do apply. Yes, it definitely applies. You have been working with this company on and off, and you are currently employed with them, and for the last 1 year you have been employed with them. So you qualify for the L1 petition, but the employer has to apply for the L1 petition for you, so you can come. It's called the intra-company visa. So from the foreign company you can come over here and work on in their US office. So yes, that can be done. So I hope I answer your question, Mr. Raj Kumar Sahgal. If you have any other question, or your employer has some questions, the company has some questions with regards to that, you can send us a message and we can help you with that. The last question I have is that I got married to my second wife on March 2020. So he was married previously, Mr. Robert Keaton. He was married previously, and then I got married to my second wife. So the second marriage took place on March 2020. My previous marriage was terminated in December 2019, so like 3 months before that, but by mistake the document states April 2020. What issue can I face while filing family-based petition? Mr. Robert Keaton. Okay, Mr. Keaton, I hope I can have a good news for you, but the thing is that bigamy is not allowed in the United States. So one of the basic rules and regulations is once you are filing, especially the family-based petition, when you are filing a family-based petition based on marriage, if you were previously married, your previous marriage should be accurately terminated. Divorce final, complete divorce decree is provided to the officer, because that's a requirement. And you move forward with the next marriage. You got married, and based on that marriage you are applying for the family-based petition. Your petitioner is applying. Then based on that, it's very important. The date's role is very important there. You cannot ignore the dates, and you cannot go in front of the officer with the documentation which has wrong dates on it, or which is creating a contradiction right there on your petition. So I hope so that the documents, if you have already filed the petition, I don't know if it's already filed, or you are still in the process of filing, I highly suggest that please provide them with the accurate documents, because you cannot show that you are not properly divorced before this consummating this marriage. So the marriage which happened on December 2019 is only legal or valid if the prior marriage has been terminated through divorce, and the documents support that fact. So kindly, if there is some mistake on the documentation, kindly make it correct according to the dates, and your documents should show the correct dates on the correct dates on these kind of documentation which supports your family-based petition, and you are basing your marriage petition based on these documentation and on your second marriage. So I hope it helps you in clarifying. Again, I'm saying, like I mentioned before, that when you put in a document, when you are putting in a petition along with your attorney, or when you are putting in a petition or application and you are trying to, you are getting help from someone, or you are doing it for yourself, which I never recommend. But if you are, even while you are working with your attorney, it's very important that you provide them with the asked documents. You provide them with the supporting documents and relevant supporting documents. Irrelevant documents kind of mess up the case instead of helping you to get good results, because if the officer is not clear in what kind of documents you have provided, and those documents provided are supporting the matter, then it will not be able to help you in getting your petition approved or in your case approved. So very importantly, please do put in the documentation which is relevant. Try to avoid irrelevant documentation which is not linked with the kind of petition what you are filing. And I hope so that in that situation you will be happy and you will get the results, and less time will be wasted in getting the RFE request for evidence, coming up with the documents and providing them with the document, and again going through that more scrutiny. So I think so it's important that initially when your documents are being submitted, most relevant and more documents, complete documents should be provided to the officer, so he knows it's easy for him to decide on your case. I hope I have answered all the questions, and I promise you that next time we will be more frequent on Monday with Mispa, and we will come up with more related immigration issues and the immigration rules and regulations which will be coming up, and we will be coming up with the good news for you. So if you are working on some petitions, if you have some questions, if your employer, somebody is sponsoring you and you have some questions with regards to that, if you have applications you are looking into and you have certain immigration questions, kindly do contact us. Our contact information is in the slide below, and you can see that there with all the details, and we will like to answer your question. So until I see you next Monday, I wish you all the best, and I hope everything is well for you during all this week. Thank you very much, and